I've brought up motor vehicle accidents, which would have the application of accident benefits, which would enable people to get treatment. And so either the treatment won't be covered because it's found not reasonable and necessary, or these individuals fall under the minor injury guideline and exhaust what they're able to get, or they use up all of the med rehab available with these much lower limits that have come into play in recent years. What about in non-motor vehicle claims? So a person who injures themselves by a slip and fall incident or by any other type of incident, a bouncer assault case of mine, for example, could they come for treatment loans in those scenarios?
100%. We have funded, there are sexual abuse victims who require counseling services, and slip and fall cases are very, very common. So absolutely, there's, as long as we have a whole team of lawyers and legal professionals who look at these underlying cases. And again, it's their assessment of the need of the individual and essentially the value of that case, which is effectively the security for this funding that we look at. But the benefit of our treatment funding is the ability for you as the skilled lawyer to appreciate that this isn't something that should be coming out of your client's pocket. Even the interest on this funding, your client has every right and even a responsibility legally to try and get back to their pre-accident.
That's right. The law says they must mitigate their damages. What does that mean? That means they need to do everything they can to get better and get back to work or whatever the case may be. And how can they do that when they don't have the funds to do it? Right.
And the catch-22, I'm sure, in your settlement discussions with defense counsel is, well, what do you mean you're discounting my client's need for ongoing payment for these treatment expenses just because they haven't had those services for the last year or two? Well, they haven't had them because you've refused to pay for them or wouldn't offer an advance on the case for my client to be able to access them. So how was my client supposed to be able to mitigate their damages? Well, that's where we step in. So we give the lawyers a tool, even at the outset, we call it a term sheet. It basically is like a letter that sets out the terms of our funding, which we offer to every lawyer in these cases. And even the personal loans, by the way, where income replacement benefits are cut off or less than what the client was earning pre-accident, that gives you the ability to say, listen, to the defendant, my client would like an advance on the tort case, or we'd like you to reconsider your denial of this treatment plan. And guess what? Your failure to provide that funding gives my client no alternative than to have to borrow from a third party. And here are the terms that they've already been offered by BridgePoint Financial. And this is notice to you that if you fail to provide this funding and you force my client to have to go to this lender, then any interest costs accrued will become part of the claim. And we've had many cases, by the way, where they have capitulated and accepted that. Unfortunately, we just don't have the decisions where they're definitively obligated to pay that. So they still fight it, but they do concede in many cases that is an exposure on them.
Well, I have an issue with defense lawyers, or their insurers, I should say, because it's not up to the lawyers. I can't fault them. But I ask for an advance payment in tort claims where my client has significant claims. There's no issue with respect to liability. Mm-hmm. And in one particular request right now, my client had to she had to pay a lawyer because her husband was in a coma, and she had to get a guardianship application done and a judgment obtained so that she could speak on his behalf. And the accident benefit carrier was found not to be responsible for that payment. It was found under the new rules to not fall under the category of med rehab. And so I asked for an advance payment. Mm-hmm. There's $10,000 in legal fees owed. There is no issue that the claim is worth more than that, and I just can't get them to pay. And my client in the same accident has sustained an amputation to her leg and is unable to return to work. Mm-hmm. Her husband was in a coma for a year before he eventually passed away. She has no way to pay.
Sure.
And so what do we do now? I mean, waiting for a response, but I'm pretty sure they're saying no. Well, they've already said no, but I've asked them to reconsider. So, what do we do?
Well, we'd love to offer you a little extra leverage, and I can report that many lawyers have been pleasantly surprised because historically they know that the response to those requests for an advance payment is usually a resounding no.
Mine has always been a no.
Yes, well, of
to
course,
date.
because let's face it, why would they? At the end of the day, they are sure that they'll be able to get away. There's not going to be a penalty for them. Why are they going to go out of their way to assist your clients? In many cases, is the sad perspective that is taken here. But they will listen when there is the possible exposure of, for example, a meter running on funding that the client definitively incurred solely as a result of the damages that they sustained, and they have responded to that. And what we're ideally hoping for is a precedent case where a judge will recognize that the insurer's failure to provide that and the cost that the client incurred in borrowing from a third party is a legitimate part of the claim. Where there have been those scenarios, they're smart enough to recognize the damaging possibility of such a precedent, and they will pay the amounts. That has been our experience to date. But we keep trying, and there've been some great cases to the tune of, even the prosthetic limbs that I mentioned, and other very serious expenditures, requiring individuals to be carried up and down stairs by a family member in a wheelchair because they fought over the housing needs assessment costs that were incurred. Because even if they ultimately pay that, but they buy a year or two to argue that, well, the amount maybe is too expensive, they still win. That's still money that they're earning a return on, in their reserves that they haven't had to pay out. So that's still a high five in that case to have avoided that. So that's their modus operandi, and
it's unfortunate because my clients are suffering, and
it's tragic in many cases. I agree with you.
So we've talked about the plaintiff side of things, so the individuals suing, basically my clients, and the financing that's available to them. Mm-hmm. But let's talk about the services that your company provides to lawyers.
Sure.
So one of the areas is disbursement financing.
Correct.
And in terms of disbursements, these days, my disbursements are getting racked up on files because I find that insurers are driving my files longer, unless I want to settle
You're not
out.
the only one.
Yeah, good to know. Good to know. It's not
Yes.
just me. However, they're driving them longer and harder, and that means more costs because when you have litigation, the amounts we have to spend to run the litigation keeps going. When we are preparing for a pretrial, I have to serve my expert reports 90 days before pretrial. These reports range, they could be cheaper than what I'm saying, but the average I find is between $2,000 to $6,000 for an expert report. They could be more, depending on what you're getting. Yeah, and depending on the size of the case. Yeah,
Yes.
they're often higher. But,
Yes.
and you don't just get one report. I have to get something from the accountant. I have to get something from the orthopedic surgeon. I have to get something from the psychologist. I'm giving examples, but basically you're not just getting one report. You're getting a few, and the dollars add up. So I know that one of the reasons they do this is sometimes to wear the plaintiff down, sometimes to wear the lawyer down.
Shocking.
Yeah. But they haven't worn me down yet.
No.
So, the issue, however, is while they haven't worn me down, I have to fund this.
Yeah.
And things have been good, thankfully, touch wood. However, what happens when personal injury lawyers don't have the funds? And it's not because they won't come, but they have to have the immediate funds for funding the litigation, the disbursements. What can they do?
Well, it's the business of law, and as I think you would agree that law schools would be well served to prepare a lot of lawyers, those that don't go into the big office building sort of corporate firm lifestyle, but the sole practitioners or the boutiques. Law is an expensive business, and
Especially litigation.
Contingency fee based legal practices are an entirely unique very capital intensive business. If I put my former corporate finance hat on, one of the things I recognized early on, obviously the business inception was to assist these accident victims and the plaintiffs and to meet the needs that were very serious for them. But I very quickly learned that the law firms who represent these plaintiffs, who take these cases on and who have to wait years and years for payment for their time and services, and then only if the case is successful, but over and above that have to reach into their own pocket to invest in all of these disbursements and the thousands, if not tens of thousands of dollars, if not hundreds of thousands of dollars, we certainly know of third-party experts to build these cases. It is a very onerous, expensive process, and it's an issue of cash flow. So you're right, there can be some significant wins and some great results and compensation when these cases get across the finish line after a lot of work is put in. But
and
there's
a lot of years.
A lot of
years.
And guess what? Putting my banker hat on, the banks don't get that, and they never will. You will litigation boutiques and litigation law firms will never be able to access traditional funding, i.e., bank funding, that virtually every other business is entitled to.
The banks are completely uninterested.
No, they
completely.
They don't get. They just they won't touch your clients with a 10-foot pole, and they won't touch you with much less. So it's a challenge, and I was approached by these firms whose clients BridgePoint was helping early on to say, listen, we greatly appreciate what you're doing for our clients, and that's tremendously helpful for us to be able to get the better results for these clients. But we've got our own frustrations. Why can't our bank understand what our needs are? And they're asking us about our inventory or our accounts receivable. Well, we don't have accounts receivable. You've got investments in these disbursements.
Yes, they want to know. They always want to know about the WIP.
Yes.
And I'm like, how am I supposed to tell you exactly what the WIP is, and how am I supposed to tell you what the accounts receivable are? Because it's all on contingency.
That's right. Yes. So really, at the end of the day, it requires a specialized understanding of what the practice of litigation law is, and we have that. Banks don't, and most don't, and so we've geared our services to provide the assistance for these firms to fund these disbursements in a much better capacity than the banks would ever be able to do. So that's actually the larger part of our business. Believe it or not, it's the firms who take on these cases who, especially now here in Ontario in particular, you've I'm sure experienced it. Everyone has, whether you're one of the massive firms or an independent practitioner. It's a perfect storm. Cases are taking longer. Court delays in this whole jury requirement, which hopefully is going to go out the window, is dragging cases on. Defendants can take their time. You have to invest more and more in the experts to get a reasonable settlement out of these insurance companies, and the results as a result of regulatory changes and other reasons are lower settlement values than there have been in the past. So all of those come together to make it an extremely difficult time for the firms who have to build these cases, and we have a service and a solution that tries to address that need.
I think the description, the perfect storm, is so accurate for what has developed, because as an owner of this law firm, I can tell you that everything you've said is accurate in your description of the perfect storm. But what people fail to recognize is not only am I funding the litigation, which I'm happy to do, but I have stress, and I am admitting that. I don't think a lot of personal injury lawyers admit it, but I'm admitting it. I have stress because I have to fund this, and I want to fund it, and I want to keep going, and I will keep going to serve my clients. And that is my ethical obligation to them, and I'm happy to abide by it. But I also owe an obligation to my staff to ensure that they are paid on time, and I too have my own bills to pay, and my own kids to take care of, and the lights have to stay on, and et cetera, et cetera. So I think there's a failure to recognize that it's not just the funding. We need the help on the disbursement sometimes because we have other things that have to be paid for. It's the cost of business. It's the overhead.
Listen, that's not even getting into the overhead and advertising costs. I mean, I don't think anyone listening to this would dispute that it's a different market out there. I mean, to get your clients in the door, obviously you do a brilliant job on social media and
thank you.
And you have been a tremendous resource for the community at large and commenting on various issues out there, and that relates very well, and I think that's a very important service. But the advertising costs that firms incur, this is a very, very challenging time, in particular in the personal injury, plaintiff personal injury market. Absolutely.
One other service I want to touch upon that you offer for lawyers, expert access. Talk to me about that. What is that?
Expert access is a variation of our disbursement funding program. It really is something that just leverages what has been a very common arrangement that law firms have used to finance themselves historically, which is striking deals with experts out there in the community, the doctors, the engineers, the accountants, and others whom you need to obviously build these cases, wherein they will agree to wait to pay these experts until the case settles and you actually have the funds in hand from the underlying file. That has been something that has been negotiable in some cases. Obviously, these experts appreciate the opportunity to do this work, and for them, I guess a bit of a cost of business of doing so has been to agree to wait to get paid,
which is helpful because it goes back to the disbursement financing issue.
In my the idea of we call it supplier financing in corporate finance. That's usually stretching out the accounts payable, amounts you owe to your service providers. It's just usually 60, 90 days, and those are funds that you obviously get access to.
Not the 2 years, 3 years that
we're
waiting.
Personal injury lawyers have taken that concept of supplier financing to an entirely new level. I learned in that they will often negotiate to defer payment until settlement of the underlying files, and
which is why I was saying 2-3 years.
Well, and there aren't many businesses, and let's face it, these experts are doing this as a business service as well, who can afford themselves to wait that period of time, and I think it was done on a bit of an unspoken basis historically because these same experts do work for the insurance companies, as you know, and they get paid out of the unlimited funds that those defendants obviously have to utilize them, and they would get paid for they had a fairly steady cash flow from their other services, so they could afford to hold on these accounts. But I think the reality is it's such a challenge, going back to that perfect storm, that the demand for that from the plaintiff lawyer community has been unsustainable and can't be met. So these experts, they don't want to be funding the firms. I mean, they'd rather be paid up front. So what we have done is we have partnered with many, in fact, over 500 at this point in time, to enable them to get paid for their services right out of the gate. We step in the lawyer's shoes. We pay the expert. We, in turn, are willing to wait for payment until settlement of that file, and as a result, we offer the firm the ability to defer payment, and we offer them 2 years with no interest accruing on that invoice that we have acquired in doing so. And at that point in time, hopefully the case has resolved, because you look at the timing of these investments, and hopefully a couple of years is enough time, but we appreciate it's not always. But interest does accrue on the account starting in month 25 on those accounts. And so that better matches the cash flows of these firms. It's helpful for the experts because they just get the bird in hand, if you will, the payment from us, and they can afford to take a bit of a discounted payment because they're not chasing down these uncertain accounts receivable. We take the timing risk. We take the payment uncertainty that they have out of the equation. So they're prepared to accept a bit of a margin reduction. Also, we have so many firms who utilize this service that many of these experts have been able to benefit from matchmaking that we can offer, and lawyers as well. We have many firms who now benefit from introductions that we can facilitate to our whole network of experts, IME companies, individual doctors, engineers, what have you, that they have found tremendously helpful.
Stephen, thank you so much for enlightening us about BridgePoint and all the services that you provide to help plaintiffs and lawyers. It's been a pleasure to have you here. Thank you.
All mine. Thank you very much.